Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other week community conference call, which we hold every other Thursday. To answer your questions as best as we can, the answers are subject to the disclaimers that you would heard that when you logged into the call. Okay. I don't think we'll have time for new questions, but we should be able to cover the questions that have already been posted. And of course, any follow-ups on those questions. I didn't have a whole lot of time today to review all the questions ahead of time, so bear with me while I go through every question. Ashish G, question number 2. Approved I-140 in EB1C, priority date 2018. In October, you have filed your 485. L1A extension is also pending, currently in the 240-day period. Okay, so I'm assuming that when you filed your I-485, you were either still in L1 or you were still within 180 days of the L1 expiration. That's important. So either you were still holding an L1 or you were within the 180 days from your L1 and that you have never violated status. So that would make your 485 filing good. Otherwise, you could have a problem because Section 245K of the Immigration and Nationality Act may not protect you. Okay, you can discuss that with your lawyers. Now, the problem is that your team that you managed in India as a functional manager is being sold off to another company, and then you would work as a consultant. And I'm not sure that that's an easy case to justify as an EB1C. But because you would soon have your I-485 pending 180 days, you should be okay. See, your I-140 is already approved. So what you're waiting for is your I-485 to be pending 180 days. Once that happens, as long as you are a managerial person or executive person, the fact that there's a change in the corporate structure or the job should not be affecting you too much. Okay? But I do want you to talk to your lawyers about this, but I do not see it as a problem. The 180-day period does not require you to have the same job throughout the 180-day period. That's another interesting thing. What is required is that the status quo of pending 485 persists for 180 days. As soon as you hit the 180 day of 485 pendency mark, because your I-140 is already approved, you can be given a same or similar job within the same company or a totally different company. So your questions were, will I be considered EB1C eligible? Probably not. If the government comes after your I-140, you could have a problem. I would have to, of course, know more facts than we do. But that may not be relevant anymore because once the 180 days are over, from October when you applied your 485, you're pretty safe. Okay. Can your I-485 be approved even if L1A is denied? Yes. And that's actually happened to one of our cases from North Carolina. Ultimately, I was able to get that L1A reversed, or L1A denial reversed, but I had the EB1C approval, and that gentleman was also covered by Ac 1 Portability, so I was not worried, but I just don't like having a negative influence on the company's cases. Can you change employer after 180 days so I can maintain a managerial role? Yes, you can. You can change employers to same or similar job, and you can be outside the group of companies through whom you were sponsored for your EB or for your L1A. Okay. Is there any other option that I can continue working while my 485 is pending but L1A is denied? No, you need to have an employment authorization. So if you work, that would be unauthorized employment. Don't do that. If your L1A 240 days are over and your EAD is still not hand, of course, try expediting the EAD. you might be able to. If the EAD is not in hand, you've got to stop working. You're okay to stay because your 485 is pending, your L1 is pending, but you're not okay to work until the EAD comes. *5, if you have a follow-up question, press *5 on your phone. No new questions, please. Just follow-ups. Okay. Let's see. This one is from area code 646. 646, where are you calling from?
Hi, Rajiv ji, calling from New Jersey.
Yes, sir. Go
So,
ahead.
I understand like whatever you mentioned, it makes complete sense.
Okay.
I actually talked to my lawyer also about this. So he told me that although while the case is pending, this should not be an issue because usually they don't open I-140 during the case. I mean, anything can happen, of course. But he told me that at the time of interview, at the time of green card interview, at that time I should have some reportees because if the assessing officer will ask me about a managerial position, then I might be in trouble if I don't have the management reportees at that time.
I disagree. Anything else?
Okay. And like you said that if it is pending for 180 days, so if the India company is sold off before 180 days, then it's a trouble?
Well, the thing is, as long as your 485 is not questioned for 180 days, if your eligibility changes, I don't think anybody can touch you. Okay?
Okay.
So the race is really to stay pending for 180 days. All right?
Stay pending for 180 days, which should hopefully be by end of April.
Yep. Okay. Good luck.
Okay. Thank you, Rajiv.
You're welcome.
Thank you so much.
You're very welcome, sir. Okay, so Ashish has a question about, this is number 3, post-completion OPT and employment issues. Applied for an EAD based upon post-completion OPT. I'm on F-1 visa. OPT was approved. EAD start date is November 2nd. However, my program end date is November 24th. Now, I don't think this is a problem, Ashishji. You can double check with your DSO, but this sort of minor phase shift where you have the program extending a little bit further and it goes into your EAD, personally, I think you can actually work and study at the same time to finish your program if you wanted to. But double check with your DSO. I don't see it as a problem. *5. If you have a follow-up question, press *5. Okay. So then let's go on to the next one. This is from Ronak, who says, I'm a Canadian citizen applying for a TN visa during the presidential proclamation. Ronak, I don't remember off the top of my head. I've done a study on the H1s and the L1s, and actually on my LinkedIn page. Oh, there is a follow-up question. Guys, you gotta have to be a little quicker with your follow-up questions, okay? So sit tight. I'll get to you. No new questions. If you have a new question, put your hand down. Press *5. But if it's a follow-up on the F1 question, I'll be happy to answer. So going back to the TN, I haven't done a study on the TN specifically. I don't recall exactly what the law said about it. So can you apply for the TN visa? As far as I know, we are still getting TNs. And all of this may be more of a rhetoric than anything else, because December 8th, one of the proclamation is expiring. So even if you were covered, I think that gets okay. Can I apply for a TN visa while I'm waiting for the NVC processing? You can always apply for a TN as long as you're not covered by any of the proclamations. Should my job title match exactly the professions listed in Nafta? No, it doesn't, but the job duties should correspond. So many times there are some very open-ended titles. For example, there's a title called business consultant. Very open-ended. People who have a degree or have 5 years of experience can qualify. And the titles are just too many. So it's not a title to title correspondence. Often it can be, but it's the job description to job description correspondence. Okay. I recently got the Canadian passport. Indian passport is not valid. Do I have to inform the NVC of this change? I personally don't see any need for that because the green card is attached to your country of birth. But whenever you get a chance, you should update your information. It also does not hurt to check with the NVC. Uh, the sooner you get your papers straightened out and aligned, the better off you are. But this is not a deal breaker. I don't see it as an issue. Okay. I guess the gentleman who had the hand up has put it down. *5 if you have a follow-up question. No new questions, please. Follow up on this, TN. Okay. Misdemeanor. I have one misdemeanor for shoplifting. It was expunged. By the way, expungement has no meaning under immigration law. So even if the crime is expunged, it must be mentioned. The answer to the question which is asked on the forms often is, have you ever been arrested? Yes. Have you ever been convicted? And if you've been convicted and then the crime has been expunged, it is still yes. Expungement is not recognized under immigration law. My wife's green card is currently AB3, company is filing I-485. We do not want to share my misdemeanor details. Yes. We want to add me in the green card with the help of an outside attorney. How late can she add me? Look, she can add you at any point of time. Even you can actually go in for a green card 485 even after she gets approved, as long as you're maintaining your own status. The only problem is that when you apply for your 485, her priority date must be current at that time. So let's say that you want to apply 6 months down the road. It's okay. You can, as long as her date is current. Let's say she gets approved and you haven't yet filed, but you are maintaining your own status. Can you still file a 485? Absolutely. As long as her date becomes current, even though she's approved. Okay? And she has no complications because of your misdemeanor. That is not an issue at all. Okay? Yeah, you should be fine. And by the way, she can apply for you as her spouse even when she has a green card. So if for some reason you don't apply and she gets approved, you can still apply your 485. At the same time, she can also file another green card in the family-based category for you if she wanted to. Okay. So that's how it works. *5 if you have a follow-up question. So your information is incorrect. She doesn't have to be a citizen to apply for her spouse. Even green card holders can. Okay. *5, no question. Let's go on to the next one. Document checklist. Okay, this is a little bit difficult to answer piece by piece. But the bottom line in public charge issues is they want to look at your overall financial history and figure out whether it is likely that you will have to draw upon the government resources to support yourself or not. So what happens in these cases is no one factor is necessarily the determinative factor. But typically young, educated people, even if they have a bad credit history, as long as they have the job offer, potential for job, I don't think it's going to be a problem. And by the way, Mr. Biden has said he will probably go back to the old, much more relaxed criteria than this nonsense we have to do right now. So this may not be around too long. Do this check the credit score? I think they do. Driving history, it's not a big deal unless you have criminal charges. Sometimes too many traffic tickets can become a problem for your citizenship. I think I had like 9 or 10 in 2 years when I got my citizenship. It wasn't a big issue. The officer just said, wow, you drive fast. I said, well, sometimes I don't have a choice. I got to get places. So yeah, it can happen, but normally it's not a big issue. Social media posts, they can. If you've been trying to get people to go for jihad, yes, hopefully not. Criminal offenses, yes, it can. It depends upon the type of criminal offense, if they are crimes of moral turpitude or not, how much punishment was imposed. These are some of the things that can become a problem. Facebook join groups, again, only if you are into criminal behavior. But if you have a particular opinion about politics, I don't think that can become a problem. Okay. If you look at my Twitter account, my day begins by yelling at the Republicans. I have just been disgusted with the politics of this country on the right. So therefore, the fact that I post a tweet against Trump calling him a jackass, does that make a difference to my green card or naturalization? Of course not. It's a political opinion. My right under First Amendment is protected. But if I say to somebody, let's pick up the gun and revolt against the Republicans and the government, that is sedition. That could be a problem. That's a criminal offense. Okay. So number of C card, I guess you mean credit cards and bank accounts, refunds received. All of this is a totality. If you're a young educated person with a job or a job offer, you shouldn't have any problem. Okay. And I'm not even sure, like I said, how long these are going to be around. Payal, if you're on the phone, press *5. If you have a follow-up question, *5. Okay. Kayak, this is question number 7. Consular processing and green card when dates are current. I'm an Indian citizen, Australian PR in Australia, working for a local company there. I was in USA on H-1B until May 2019. H-1B expired in December 2019. I have an EB3 I-140 from your previous employer in the US. I understand that in my situation, I would have to proceed with a consular processing or come back into USA with an H-1B and then do a 485 when your dates are current. How do I initiate the change to consular? There's a form called I-824 that has to be filed. You have to get in touch with your previous employer because they have to have the job open for you and you've got to have that intention to take that job up. Can I get consular processing in Australia? Yes, you can. Don't have to go to India. And you do need to talk to your employer to get the same position. If you don't have same employment, you want to talk to a lawyer, get yourself a legal advice, see if there's any way out of that, but it's difficult usually to get out of that situation, okay? *5, if you have a follow-up question, *5. All right, let's go on to question number 8, transition from F to H. My daughter's H-1 application, she'll be completing undergrad in March. Is there a need for a degree certificate or final? Yeah, see, here is what I remember, and I think I'm pretty sure, at least last year it was like this, that even if you have not finished the degree, you can do the registration, but by the time you file your H-1, after you get selected and you get your filing done, you must have your degree in hand. I think that's how it was. If her case is selected, will transcript suffice? So normally, for H-1 purposes, if we have a letter from the school that says all requirements for the degree have been concluded and only the formal award of the diploma remains, that's enough usually. We've used it in the past. It's not been a problem. Okay. *5, if you have a follow-up question, *5. Okay. Question number 9 says, I'm on H-1, expiring December 2020. But because of the wage increase issue, I'm waiting for the lawsuit decision. By the way, you can also reach out to private wage survey sources. There you normally have, for most jobs, anywhere from $10,000 to $30,000, $40,000 lower wages. So the law allows you to use private wage surveys. We are using them all the time. Yeah, you should wait because we do want to see how these lawsuits play out. And if you have the time, because you have till December 2022, you can't apply for an extension before June anyway. It's December 2020, not 2021. Okay, in that case, I don't see how much time you have to wait. I mean, you're already in November. So I think you need to move forward. You need to move forward with this. And let's see what Mr. Biden does when he comes into power. Yeah, I don't know how long you can wait. It depends upon your comfort factor. It is advantageous to wait and see if the law changes in your favor. Star 5, if you have a follow-up question, star 5. Okay, let's go for this one. This is area code 361. Where are you calling from, 361?
Sir, I'm from Boston. So
Boston. Okay, go ahead, sir.
yeah. So the only concern I have, so my employer is ready to file the case, but he was waiting for this lawsuit for decision. And the only question I have is if I apply extension and if I get all the extension again, and later I can re-amendment with the new wage rate.
Yes, you can. Absolutely.
Once
That's exactly what I would do. Yes, sir.
Okay, so there won't be no issue, right?
I never say that there will be no issues. The law does allow you to do it. That's enough. Okay.
Okay. All right.
Government can always create issues out of nothing. But legally, you're allowed to do that. I don't see why not. Okay.
All right. Thank you, sir.
You're welcome.
Appreciate it.
Good luck. Okay. Question number 10. I-485 primary derivative. My spouse and I are working on EAD through EB2, my EB2. She's eligible for EB1. If her I-140 gets approved, can we transfer the underlying basis to make her primary and me? Yes, yes. So when you have husband-wife, husband primary, wife derivative, both 485s pending, but then wife can become primary and husband derivative based upon the same 485 filings. At least that was the policy so far, and I have not heard of anything changing. So yes, that can be done. I don't see why you should be filing new 485s, but always check on this closer to when you are about to file. So I'm assuming the hand that is raised is in relation to this question. I hope so. This is from area code 216. 216, where are you calling from? 216. Hello? Hello? Okay. Going on to the next question. Rajita wants to know how long for interview after the priority date becomes current. Well, I don't think I can give you a number because a lot depends upon the local waiting times. And I've seen something ridiculous. There was a waiting time that I was looking at in the local office, and the estimate they had given was like 9 to 29 months or 30 months, something like that. That's a very big differential. So, too many variables for me to really comment. I can't tell you how soon. When I get my biometrics and interview, is it when my priority date becomes current in final action date chart? No, I think they will proceed with adjudicating your application based upon the dates for filing chart. Okay. So they, as far as I remember, they cannot give you a green card number until your final action dates become current, but they can continue with the processing. Okay, this is a, what is this scenario? What happens if EB3 final action dates become current prior to EB2? Do I need to downgrade? Yes, you're not automatically entitled to a lower category unless you are also entitled to it with an I-140 approved under it. So you could have an EB2, EB3 both approved on the same perm. That way you could flip from one to the other. Go from EB3 to EB2, back again to EB3, or back to EB2. It doesn't really matter. But you got to have two I-140 approvals for that. Okay. Let me go back. There is a question from area code 216. 216, where are you calling from?
I'm calling from LA, California.
Yes, sir. Go ahead.
Yeah, this was regarding interfiling.
Right.
A previous question.
Hello.
There is an error on GC
Sir, your
My
voice is not
primary
clear.
is
Hello? Your voice is not clear. I can barely hear you. Can you get...
what I'm saying is there is a there is a there is a error on my green card
Uh-huh.
visa category.
Okay.
Instead of primary, I have secondary.
Can't hear you,
So
sir.
my
I have
spouse is
no idea what you're saying. Can't hear you. Hello?
let me
Okay, I can't hear you.
hello.
Sorry. I gotta move on. Area code 408, California, I guess. Go ahead, please.
Yeah. Hello, Rajesh. Thank you. So you mentioned about having two I-140s in approved. So basically for both the categories, and later on, let's say EB2 becomes current. How do you now inform USCIS to use that EB2? Is it like a simple process, a letter, or does the employer need to be involved? Like, how do you go about it?
It's a simple process. It should only involve a letter or even a phone call followed by a letter. Does the employer need to be involved? I don't see why, because it's your 485 and the I-140 is already approved. So the employer is pretty much out of the picture at that point of time. I don't see why that would be important. Okay?
All right. Thank you.
You're welcome. Good luck, sir. Okay, let's go on to the next question. So this is H-1B visa potential immigration issues for being outside the USA for more than 1 year. Rakesh is on H-1B, got a stamping, came to India been there for last 1 year. I can work remotely, working from India. What kind of questions can I expect? This is not a big deal, Raghav. Even before this pandemic time, I had a case in which a project was supposed to begin, and it was a project with the DC government, but the project got delayed. My client, a local company, had an office in, I think, Chennai, and another office in Washington, DC. So the guy whose H-1B had processed, who was working for our India office, was not able to come for almost 2 years. And in the last year of his H-1B, the project got activated. He was fine. He had no issues coming into the United States. They did ask him. We had him carry a letter fully explaining the situation. The project was delayed. He continued working from India for the Indian office. Your case is quite similar. Your case is in a way even better. So I don't think this is going to be a problem. *5 if you have a follow-up question. *5. So basically what they're looking for really, Raghav, is that you still have the job and maybe some reasonable explanation why you're starting off late. Okay. Let's go on to the next question. This is number 13. Laid off. This is Darpan, who said laid off due to COVID, and how does that affect my STEM OPT? Let me see if I can answer this question. I may not be able to, but let's try. I graduated in May 19th with a master's degree, worked on OPT for 1 year. Okay. Filed for STEM OPT. Case was received. Got laid off. Oh, yeah. I was just looking it up the other day for somebody. Very similar situation. There's a frequently asked question on this. Who has it? Kind of skips my mind. And these kinds of situations, if my application is denied, does losing a job affect the adjudication of a STEM OPT? I don't remember, Darpan. I don't remember what I found out. But as I remember, there was definitely a fix for it. So it was not a problem. One of our clients was in this situation. So I don't remember exactly what the solution was, but there was a solution and it was not a problem. So here's what I would do if I were you. Talk to your DSO first. Talk to the International Students Office. Talk to the DSO. And if there is advice that you want to double check with me, you can, but it's better that you double check with either the ICE website where they have all the frequently asked questions, or even call Service or SEVIP. And also you could call USCIS. Make notes of whatever you are told, the date and the time and the conversation. Okay. But I do remember this happened to one of our clients. It was not a problem. We were able to resolve it. How I resolved it, we resolved it, I don't remember. *5 if there's a follow-up question. *5. Okay. Next question, number 14, is about AC-21 portability, I-140, and starting a new venture. Okay, let me see. And this is pretty long set of questions. I'll do the best I can with whatever time I have, because I do have to go back to work. So I'm in the US on an L1A visa. Employer sponsored me for EB1C. I-140 filed concurrently. EAD and AP have been approved. I-140 and 45 are not yet approved. I want to co-found a startup with an associate. Does AC-21 allow me to port to a new startup? That will be funded by outside investors. General and operations managers my code. Substantially the same job will be involved. New salary would be lower. Okay. Have annual expense of about $375 and no revenue for about 2 years. Okay. So your questions are, do I qualify for AC-21 portability before my I-140 is approved? If the employer says they're not going to withdraw, yes, you can. Because the law doesn't require you to hold the job for 180 days. Just that your 485 stay pending 180 days and your I-140 is approved. So the answer to question number 1 is, you won't do AC-21 portability because there is no portability before I-140 is approved. But you can move on your EAD and take a chance that there'll be no problem. That's perfectly legal. I had a case where we ended up having a lawsuit filed. This was a Minnesota case where the employee left the employer after 3 months of 485 pending. The government tried to come after it during the interview, said, well, you didn't wait 180 days. And the argument against that was, the law doesn't require me to wait 180 days. Merely, I don't have to continue the employment. The law only requires that my I-140 was approved and my 485 was pending 180 days. In your case, as long as the I-140 gets eventually approved, you should be able to use portability the moment you are 180 days or over 485 pendency. Okay. These are a lot of questions, but let me see if I can quickly go over them. Do I qualify for AC-1 portability after my I-140 is approved? Yes. And do the EB1C criteria apply to petitioner or transfer to new employer? They do not. The new employer doesn't have to be a part of the set of corporations who sponsored you, and there is no requirement that you must have worked for a branch, etc. of the company outside the US. Just the job description have to be same or similar, the job descriptions. Does the petitioner still require the intent to employ me, or does this transfer? Well, the I-140 from the old employer is approved based upon the intention which existed when the I-140 was filed. After that, if the intention changes, as long as the I-140 was approvable when filed, you should be okay. Do these criteria have to be true? I already answered that question. Can I work on this startup on the side? Yes. Can I be paid? Yes. You can use your EAD, and as long as you're maintaining your full-time job, you can maintain another full-time job with the startup or a part-time job with the startup or a flexible scale. Some days you work 8 hours, some days you work 1. That's okay. No problem. You can simultaneously do that. That's actually pretty safe. And you don't need to leave USA to come back to change to EAD. Merely starting the use of your EAD through annexing it to an I-9 takes care of that. You don't really have to do anything here. *5, if you have a follow-up question, *5. Okay. Question number 15. 221G admin processing H-1B stamping. Came to, I'm on H-1B visa good till 2021 February. Came to India to visit my parents, went for stamping, issued a 221G, no updates. Is there a way to get an update on my case? Yeah, file a lawsuit. Is there another alternative way to expedite my case processing? Very difficult. Well, we have a case pending against the U.S. Consulate in New Delhi. We have a lawsuit against them. And let's see how that goes. I'm in touch with the opposite side counsel. After we filed the lawsuit, the government has assured their lawyer that they're looking at the case, because delay cases, you've been there almost a year. So delay cases should be attacked through a lawsuit. That's what you want to do. That might be something you want to consider. Other than that, I don't see any way you can really expedite these applications. People try through congressman's office, or even through establishing an urgency or extreme need through letters from the employer, etc. Sometimes they work, but lawsuits can also work. So those would be the choices. Having your employer contact the consulate with the statement of what the urgency is, with you contacting, or your employer contacting, a congressman's office, and the third one, of course, is the lawsuit. Okay. *5 if you have a follow-up question on this. Okay. So, oh yeah, there is a follow-up question. Area code 847. 847, where are you calling from?
Calling from Chicago.
Chicago. Go ahead, sir.
Sir, so for you suggested we can file a lawsuit. So can we go through with your firm? And
yes, absolutely.
How can I?
Absolutely. We'll be happy to assist, but you can also go with your own lawyers. The lawyers who did the H-1B. If you want us to represent you, it will be better for the employer also to join. That's usually the better way to do it. I have both the employer and the employee join. It doesn't matter who pays, but both parties can join. And that's when we file the lawsuit, file a complaint, get it served, and hopefully try to get the matter settled if we can. Because if the lawsuit proceeds, then it's just a waste of money. And normally they don't proceed. Normally they are settled, but not always. So, of course, you can withdraw. Before the government answers the lawsuit, you can withdraw anytime. Once they answer, you can withdraw with the permission of the court. So in other words, you don't have to go all the way in the lawsuit. If it doesn't settle, you can ask to be excused. That's not really something that's beyond possibility. That's all. That can always be done. But the best time to withdraw, if in case you're not going to go forward, is before the government answers. Once we file the lawsuit, they have 60 days to answer. Okay. And if you, like I said, if you want us to represent you, just send me an email to help@immigration.com. help@immigration.com. I can have a call set up, and you may want to invite your employer to join us. Okay.
Okay, so like the best scenario, should we go for a lawsuit?
No, I really at this point, unless you have some urgency, because we have an incoming administration, in 2-3 months things might change drastically. You waited this long, you could wait another couple of months, but if not, let us know. We'll be happy to slam a lawsuit on the government. Okay.
Okay, thank you.
You're welcome. Yeah, I have to consider where the value is. Just blindly spending money is not a good idea. But if the money brings us value, then definitely we should. So here, with the incoming administration, things might be different. I'm hoping. Rahul Singh Khokar, Presidential Proclamation H-1B stamping. Rahul, I'm not going to remember. I'm not going to be able to answer all your questions. But I have on my LinkedIn page, you will see that I have put out a schematic, like an info map on how you can be exempt from an H-1B. If you are already in USA when those proclamations were announced, when was this, June of this year, then you're not covered by those. There are many exceptions, okay? Visa expired on 26 December 2019. Got extended. I was present in the US throughout 2020. Yeah, so you are exempt from the proclamation anyway, but I don't know what the current status of issuance of visas is. I am being told, somebody told me today that they are issuing visas, but they are doing it by appointment only. So you can double check, but as far as theoretically is concerned, there's no issue that you should be able to get a visa stamping without being subject to the proclamations because you were in the United States. Okay. *5 if you have a follow-up question. *5. All right. Change of status from J1 to F-1 Visa and Biometrics. I'm on J1, post-completion training, applied for change of status from J1 to F1 in July, no biometrics. I got my PhD position with assistantship. Can I take classes during spring semester? So, as far as I know, you can, because if your J1 allows you to, because your J1 was an educational J1. So you could have taken classes on J1. In those circumstances, even when the F1 is pending, you should be able to take classes. You will not be able to do assistantship, but you should be able to take classes. Double check with your DSO. Personally, I don't see any problem with it. Press *5 if you have a follow-up question. Press *5. Okay, question number 18. Understanding the Visa Bulletin. Currently in USA, which one should I look at? Well, so if you are inside the USA in legal status or allowed to file the 485, you should look at the Visa Bulletin, and the Visa Bulletin refers you to USCIS website where they have the dates for filing. So, and they will tell you coming month use the dates for filing chart if you are filing a 485. So you should begin by the visa, look at the Visa Bulletin, go over to the USCIS website, see what they suggest for the following month, and then follow those instructions. Oh, I'm sorry to hear about your father. In August 2020, her case was not approved, status was received. See, I don't think she's protected by the survivorship. There are two kinds of survivorship, and I don't remember exactly off the top of my head. You can do a search for USCIS survivor benefits. She may be able to have a substitute. I think there is that provision. But for survivor to continue without a sponsoring petitioner, they have to be actually in the United States. So I think she should be able to substitute her brother, but no other benefit is available. Have it double checked, do some research. I don't remember the details, but we've done this a few times. There are people in our team who have done this a bunch of times, but I don't remember all the details. Okay. *5 if you have a follow-up question. *5. Okay. So there are two. This is question number 19. We are two Indian citizens on STEM OPT working as assistant professors in a Native American college in North Dakota. Want to apply for an H-1B. Employer cannot pay the new wage level 1, which is $90,000. That's crazy. How are the non-profits affected? They are being affected as well. I just looked up a wage for Idaho. Somebody for the position of a postdoc. Their employer had called me, and the salary they were offering was $50,000 for the postdoc, and the local salary under the separate Acquia database, There are two databases. One is for normal for-profit, and the other one is for the exempt organizations like schools and colleges, etc. Even under that, the wage was like 71,000. So what I've told him is what I'll tell you. You can look for an independent survey, a third-party survey for that area. Have your lawyers look into it because there are certain requirements the wage survey should meet. We have been using now private wage surveys for the last couple of months. Seems to be working okay. But once again, Mr. Biden, once he's in power, he should be able to recall some of this without too much difficulty. Okay. *5 if you have a follow-up question. *5. All right. So the last posted question today is, based upon the info we got from the conference call, we applied for a compelling EAD in the 60-day grace period. Good. No biometrics yet. Has anyone who applied for this EAD category gotten EAD approved? I don't have any idea. I wouldn't even know if our office has processed a few. So to the best of my knowledge, no, because I do look at the outgoing papers before they go out of the office, especially compelling circumstances EAD, because the compelling circumstances have to be proven. So no, I have no experience with this post-COVID. You're not on H1, but you're not accruing unlawful presence. That is correct. Can one travel and re-enter? And the answer is no, you cannot. If you travel out, then you will have to get an H1 visa stamping. After an H1 approval, when you come back, you'll be out of the compelling circumstances EAD. Is it possible to get some kind of a parole for travel? To the best of my knowledge, no, but I have never tested this personally. I did have a client in this situation, traveled out, came back on H1. They were back on H1. No EAD anymore. Okay. If I come back into full H1 status, can my wife enter on a B1, B2? That's normally not a good idea, because a B1, B2 is for a short visit, and if she wants to convert to an H4, using the B1, B2 can cause all sorts of problems. Okay. So I would not recommend entering on a B1, B2. Okay, I think we've covered everything for today. *5 if there's a follow-up question on this that I just discussed. Okay, you are calling from my neighborhood. Go ahead, please.
Yeah, I'm sorry. This is a different question. I could not add it to the questionnaire.
Okay.
This is for my parents who are green card, and they left for India 2 years back with a valid re-entry permit.
Right.
And that expired on July 2020.
Right.
And now they want to come back, but we have been sending emails to the embassy, and they said file an SB1.
Yes, that's exactly what they need to do.
They're not open.
Right. Right. So
they're not open.
Whenever they open,
and how long do we wait? So what are the options?
You have to wait as long as it takes, because if the consulate is not open, there's nothing you can do. So keep in touch with them and keep track of your emails that you've exchanged with them, because during the time they are closed, I don't think they can hold you responsible for applying for an SB1 any earlier than that. So go ahead and keep in touch with them. You have to wait as long as you have to wait. Okay?
And if they apply for SB1, they still have to do the medical test and DS-260 again?
I don't remember that, sir.
I'm trying to
I don't remember the procedure. It's an abbreviated procedure. How far it is abbreviated, I don't remember. You have to look up at their website. Okay?
Okay. And one last question. If there's an emergency, can they just fly in and talk to the agent here? And
they will not be allowed to board the plane, sir. They will not be allowed to board the plane. It is the airline's responsibility to check the papers. If they see somebody who's been out for a year on a green card, they will refuse them boarding. Okay?
Okay, thank you very
You're
much.
welcome. Good luck.
And one
So you
thing
have to
you
really
said that
let me
if it's
go.
an emergency, file.
I have other people waiting. So, okay, go ahead and finish what you're doing, but let's try to be a little considerate of other people also. Go ahead.
Yeah, last one question is, they said that if it's an emergency file for DS-160, so do you know how that works? Like
They probably are
come in to
talking about,
register and then
I don't know
they lose their
exactly,
green card?
there is no such thing. There could be a travel foil that might be available in limited circumstances. Ultimately, that would still be a parole at the airport. So the travel foil only allows you to board, but it doesn't allow you to disembark. Ultimately, it will be the CBP's decision. That's what I think they are talking about. Okay. So, but do a Google on travel foil. Okay.
Okay.
Good luck.
Okay. Thank you very
You're
much.
welcome.
I really
You're
appreciate it.
welcome.
Thank you.
Okay. All right, guys. Anybody has any questions? Press *5. I still have 10 minutes. I'll do the best I can. Anybody has any questions? Press *5. Okay, I have one from area code 216. 216, go ahead, please.
Yeah, this question is regarding interfiling.
Mm-hmm.
Yeah, my spouse applied for EB3 as primary,
Mm-hmm.
and later my employer also applied for my I-140 in EB2.
Okay.
And in 2007, we applied for our 485 petition with my wife as primary and me as secondary. But when we got our green card, the primary and derivative was interchanged.
It doesn't matter. If
And it
as
has
long
been
as
10
the
years.
doesn't matter.
And
It doesn't matter. As long as the dates were correct. I have already covered this question. The USCIS often automatically converts the primary to the secondary and the secondary or primary to the beneficiary, to the derivative and the derivative to the primary if that's what is best for the couple. So guys, there are 10 people with their hands up.
Okay.
There are 10 people with their questions. There's no way I can cover them all today. Okay, I've got about 9 more minutes.
Thank you.
So anytime, sir. Good luck. I've got about 9 more minutes. There are 10 people with their hands up. No way I can do all 10. But keep your questions really short. Let me see how many we can do. Area code 646. Go ahead, please. Area code 646.
Thanks, Rajiv. Thanks, Rajiv. So on the very first question related to that I-140 approved and I-45 pending, India entity sell-off, I just wanted to check, like, if in case the L1A is denied, should I ask my employer to kind of apply for an H-1B on a safer side?
No, I would want you to do a consultation with your lawyers or with me, because I have to decide whether I want you to file an appeal or I want you to refile the L1. How does that impact the EB1C? There are different things we have to look at. And the timing, if you're already past the 180 days, I might be thinking totally differently. So we'll talk about it when the time comes. Okay?
Okay, thank you.
You're welcome.
Thank you.
You're welcome. Okay, let's go on to the next one. Area code 408. Go ahead, please. 408.
Yeah. So I had thank you, Rajuji. Follow-up question. So for a 485 supplement, let's say after 180 days, if I do end up changing the employer, who files for the 485J? Is it me or do I need my new employer to file that?
Your new employer signs it, you file it.
And the only requirement is the description should be similar, right? It's nothing to do with what is there on the form or anything like that, correct?
Absolutely. No doubt about that. Okay?
All right. Thank you.
You're welcome. Area code 828. Go ahead, please. 828.
Yeah, like I asked a question like previously, like it was like number 3. Like I had applied for the OPT and it was approved like from like November 2nd. But like my program ends like November.
Hang on
24th.
1 second. Hang
so
on.
like,
did you listen to my answer, sir? Were you on the phone?
No.
Okay.
No, at that time I was not there.
Then you're gonna wait for you're gonna have to wait for the recording. I'm not gonna repeat myself. Sorry. Area code 315.
Thank you, sir, for the call. So this is a question regarding the 485 filing. My former company, they filed my I-140 in EB3 and EB2, and both are active.
Okay.
So can I able to file using the EB3? No, EB3 is current now. Can I use that I-140 to file 485 now with the new current employer?
Okay. So I'm going to make this a very brief answer. I won't have time to discuss the details, but talk with your lawyers. Theoretically, if both EB3 and EB2 jobs are available for you, you can use any one of the I-140s to file your 485. Okay?
Thank you, sir.
You're welcome. Good luck. Area code 408. Go ahead, please. Area code 408.
Hi, my name is Shavya.
I cannot hear you. Can you speak up a little bit?
Hello.
Yes. Go ahead.
Hello. Yeah. I was on H-1B and it's valid until September 2021.
Okay.
And I got laid off in April and I applied for a change of status to H4 in June to avoid the 60-day grace period.
Good.
And I received a job offer in September and they applied for the change of, H1 transfer since my H4 application is still pending.
Right.
And now I received an RFP requesting for an approval on the previous benefit request, which is H4,
Right.
or evidence that I'm eligible for this current request.
Right. Okay.
Right.
I recently had a lawsuit filed against the government. Not exactly the same case, but very similar, where an H1 was applied during authorized period of stay rather than the actual H1 period. Government settled with us and they gave me my approval. Previously, they had approved without the I-94, then they gave me the I-94. And explore that with your lawyers, whether responding to this to the best of your ability followed by a lawsuit may be necessary. I think there's a possibility you might win. Worst case scenario, you have to go outside, get a visa stamp and come back. Okay?
Okay. Got it.
Good luck, ma'am.
Thank you.
You're welcome. Area code 847. Go ahead, please.
Hello, sir. This is regarding the 221G again.
Right.
I have only one question. Like, our visa approval till next year, February 26th. So, and the Indian consulate, the website says it's closed. Temporary close. So what are our options? Like, if they still won't send us any message or any update, is that this period is going to be considered, like, because consulate is closed, they can give us some grace period after February, or we have to go back if we don't get anything heard from them?
I don't remember what your case is. Are you the guy on H-1B stuck in India?
It's yes.
And you are working from India for your local employer?
Yes.
You need to,
there is like no grace the employers period. In US
there is no grace period. Get your H-1B extended, apply for another visa. If you can travel before February, okay. If you don't have a visa stamp, then you just have to extend your H-1B and then apply for it whenever they open. If there is an emergency, you can, I told you, you can explore the emergency with your employer, try to get an emergency appointment. Okay?
Okay, thank you.
You're welcome. Area code 614, go ahead please, 614.
Yeah, Rajiji, mine was the actual follow-up question on the last question, but I think there was a queue, so I'll make it quick. The compelling situation, as you said, if we get that EAD and we go out, if I already have the H1 stamped until August 2022, is there a possibility to be able to re-enter with the H1 stamp and the EAD, just like something like we do on F1 OPT EAD?
No. The H-1B stamp only
So
supports,
hang
on, let me finish. The H-1B stamp only supports travel on H-1B. It does not support travel on EAD.
Okay, I understand. So there is no like re-entry option for EAD, as you said?
No, there isn't.
With that EAD, okay. I see. Okay.
Area code 651. Area code 651.
Hi. Yeah, hi. My name is Jasraj, and I have a question on visitor visa.
Ji Jasraj,
So,
keep going.
Can you hear me?
Yes, ma'am, I can hear you.
Yeah, so my parents came to US on visitor visa on December 17th, 2019, and their I-94 was till June 17th. So we
Jasraj,
applied for their
Jasraj,
first extension.
Jasraj, have you left me a
Yeah.
message on my phone?
Yeah. No.
Okay, because somebody with exactly the same circumstance who said their parents only spoke Punjabi, could I
Okay.
talk with them? And I said I was having my office call them. I wasn't sure if you were the same person.
No,
Okay,
no,
so they came in December
no,
2019,
no.
right?
Yes,
Okay.
December 17, 2019.
Okay.
Their I-94 was till June 17,
Okay.
2020.
Okay.
So I applied for their extension
Good.
in May,
Good. Good.
and we requested till December 17th,
Okay.
2020.
Okay. And you have not
6
received a
months.
response so far, right?
So they are no.
Okay.
It still says case was received.
Hang on. Before December, apply for another extension.
Before December, apply for another extension. But is it legal to apply for another extension?
Absolutely.
Because I read many places that
absolutely we do
a
it.
visit.
We do it all the time. Now it may not be legal. It will not be legal to stay if the June extension is denied. So, but it
Yes, correct.
so
Got it.
therefore it makes sense to just apply for another extension. You create a daisy chain out of it, okay?
Sorry, you create a
Daisy chain. You chain the. Don't worry about it. Just do what I told you. Apply for an extension, okay?
okay.
Good luck.
Okay, so in case if I get biometrics, and when should I apply for the second extension basically?
Right now would be okay.
As soon as
Right now
possible.
would be okay.
Right.
All right.
Okay, so but there is no rule like a visitor
Ma'am,
cannot
I'm
stay
not going to
beyond
repeat myself.
365 days.
I already told you what I told you, okay? You can apply for an extension while the first extension is still pending. In fact, you should.
Okay,
All right.
but my question is, my dad's visa is already expired.
Visa has nothing to do with it, ma'am. It's the I-94 that matters. Okay?
Okay, got it.
No
Got
worries.
it. Thank you so
You're
much.
welcome.
Thank you.
Good luck. Area code 862. This is our last call. Wow, that was amazing. We did everything within.
Sir,
Yeah, go ahead, sir.
thank you, Rajivji. My case is like I filed the extension and I got the I-797C without the I-94.
Sir, what
my
extension?
I-94 is going to expire in 11/26.
What status? H1?
H-1B.
Sorry?
Sorry. H-1B.
H-1B. So you
I
apply.
have
Hang on.
applied for H-1B.
Wait a second.
Sorry.
Just let me understand what you're saying. You applied for an H-1B extension,
Okay.
but you got the extension without the I-94. Were you out of status?
Actually, there is a scenario like I was working with the company in New Jersey. In March, I started working from home, and my employer, in June, I joined another client. But while joining the another client in June, my employer did not file the amendment.
Okay, so you were out of status.
So we
All right.
got the RFE.
Yeah, you were out of status. So now,
So
hang on. Now you've got your approval, but no I-94. The only way out of this situation in most cases is go out, get a visa stamp, and come back.
But in this scenario right now, we don't have a date available. So 3 to 4 months after that, I'll get the date.
Yeah.
You can, till that time, I don't
you know what
like
you can do? You can look for consulates other than India. So let's say that Switzerland has no COVID-19 problem. You could call the US consulate in Switzerland and try to set up a call. They're safe. They will take your visa. They should. This is called third country national processing, TCN. Okay. So you can go to a third country.
But they mentioned like if. Sorry, sir. Sorry to interrupt you. But it mentioned like if applicable consulate Hyderabad. So
no,
that's
you can
what
go to any. You can go to any
RS,
consulate. Okay, I'm gonna keep it short. I've got one more question to go through. You can go to any consulate in the world.
My employer.
Okay.
My employer said like we can transfer to another employer and he can keep me working in this scenario.
That is nonsense.
Is it a good option?
That is nonsense. Don't listen to that junk. You are accruing unlawful presence. You've gotta go get your visa stamping done. Okay. I gotta go, sir.
So, sir, do I get
180
days?
Sir, you have a lawyer. Talk to them. This is more complicated than I can cover in 30 seconds that I've got. Talk to your lawyers. If you can't, come back next time, post your questions so we have time to talk about it. Otherwise, just set up a consultation with our office, okay? It's more complicated than I can answer in the time I've got. Good luck. Last question, guys. I've got to go then. Area code 248. 248. Okay. Obviously, you raised your hand in error. Folks, good to talk to all of you. I'll see you again in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.